Okay, so now our next chapter is employment law. In this chapter, we are going to talk about the law that governs the employer and employee relationship. First, we will differentiate what an employee and self-employed person is, and then we will talk about the employment contract, and then we will talk about what are the duties of an employee, what are the duties of employer, and then about the dismissals and redundancies. Now let's start. Now the first thing that you need to be aware of is that there is a difference between employee and self-employed person. There are two type of working relationships. Either you are an employee or you are self-employed. Employee is a person who works under contract of service. Employee is a person who works under the contract of service, while self-employed or independent contractor is a person who works under contract for services. So when you will see the contract of an employee, it will be the contract of service, while for the self-employed, it will be contract for service. Now, how to determine whether that person is employee or not? There are three different tests that we are going to talk about. The first one is control test. In control test, employer tells employee how, where, and when to do work. If your employer is telling you that how, where, and when to do work, it means that you are an employee, because he is dictating you the terms, right? So if an employer is telling you how, where, and when to do work, so it means that he is dictating you how to do things, where to do things, when to do things. Then this means that you are an employee. Clear?
Mm.
This test is invalid for skilled workers. Now, this test is invalid for skilled workers and professional workers. Why? Because professional workers and skilled workers, they are already so skilled that you cannot dictate them how to do work, right? You cannot
Yeah.
dictate a skilled worker or a professional worker how to do work. So that is why the control test is not applicable. It is invalid in situation of the professional workers or skilled workers. Clear?
Mm.
What to do work is not important, because in both relationships, whether you are employee or self-employed, what to do work, it will be guided to you by the employer, right? So what to do work remains the same, so it's not that much important. Second test is integration test. Integration test says someone is regarded as an employee if their work is integral part of the business and not merely accessory to it. If the work you are doing, it is an important part, it is a significant part of the business activities, then it means that you are an employee. But if your work is not an integral part of the business and it's just merely accessory to it, it means a less important work, then you can say that you are not an employee, you are self-employed. Okay. So in integration test says that if your work is integral part of the business, then you are an employee of the business. Okay. The next test, and which is valid for today, it is economic reality test, in which you look at the multiple factors, and then you will decide whether the person is an employee or self-employed. Okay. Now what are those factors? The first one is control. In control, you will see that who is dictating you the terms. If your employer is dictating you the terms, it means that you are an employee. But if you are doing things on your own, you are not getting any dictation from your employer, it means that you are self-employed. Okay. Clear?
Mm.
In economic reality test, just one factor is not enough to decide. You have to look at the multiple factors and then make a final decision. It does not mean that that if the control is of, let's say, employer, and you will be an employee. No, you have to look for all the factors that are available, and then you will make the decision. Okay. Second thing is provision of equipment. If the equipment to do the work is provided by an employer, it means that you are an employee. But if you are using your own equipment in doing work, it means that you are an self-employed person. You are a self-employed person. Okay. Hiring of helpers. If you are doing, if you cannot hire any helpers and you have to do the work on your own, it means that you are an employee. Because in employment, if employer will tell you to do something, you cannot hire helpers, you cannot delegate that to someone else. You can, but you have to take the permission from the employer. So usually it does not happen. But in self-employed, you can hire the helpers, who will work for you, right? So if you cannot hire the helpers without the consent of the employer, then it means you are an employee. And if you can hire helpers for your work, then it means that you are a self-employed. Okay. Financial risk. Who is bearing the risk? If the work is not done on time, who will bear the financial risk? If who will, who will bear the losses? Or if let's say there's a yes, who will bear the losses? Who is bearing the risk? So if the risk is bear by employer, it means that if you did not do the work right and employer will get loss, then it means that you are an employee. But because of your, not correct work, you are getting the financial risk, you are getting losses, then it indicates that you can be a self-employed. Okay. Payment method. If you are getting a regular payment method, if you are getting a regular salary, it means that you are an employee. But if you are not getting regular payments, you are getting irregular payments, so this indicates that you can be a self-employed. Then comes working hours. If your working hours are fixed, then it indicates that you are employee. But if your working hours are variable, then it indicates that you can be a self-employed. Mutuality of obligation. Mutuality of obligation means that one party is giving the work and other party is accepting the work. When there is mutuality of obligations, then it indicates that it is an employer employee relationship, that one person gives you the work and you accept the work. The one person gave you the work, you have to accept that work. So there's a mutuality of obligation, so it indicates that you can be a employee. And the last is profitability. Profitability, and I skipped the responsibility. So responsibilities is that if you are responsible for your work, then you are self-employed. But if your employer is responsible for your work, then you are employee. Profitability is who is getting the profit from the work. If the significant profit is, if you are getting significant profit, if you are getting major profit, then it means that you are a self-employed. But because of your work, if the major amount of the profit is earned by your employer, then it means that you are an employee. Now when you have to make the decision, you have to look for you have to look for the all factors and then make one final decision that whether this person is an employee or not. Okay. Now why it is important, why it is important to differentiate between employee and self-employed. So there are some consequences. Please read, if you can read them loud.
Do you agree?
You may please read the consequences.
Okay.
You can read them loud.
Okay. Employees receive statutory protection. Example, unfair dismissal, redundancy.
And redundancy, the
Uh,
first thing is that employee can receive the protection from the law. Like if the employee is unfair dismissed, he can get compensation. If he is made redundant, we will talk about what redundancy is. If he is made redundant, he will get compensation. While the self-employed, they don't get that. Okay. The first thing. Second is there are implied terms in contract of employment. What does this mean? That when you do a contract with an employer, you have done a contract in which some agreement will be made. Now the thing is there are some terms that are not present in your agreement, but they are applicable in an employment relationship, in a contract of employment when you are an employee. Okay. Like for example, your employer cannot harass you, he have to do his duties according to the law, he have to pay you on the time. So these terms are implied in contract of employment. Even if you haven't agreed with those terms, those are implied by the law, those are implied by the court. So that's the benefit of any contract of employment. We'll talk about that as well. Employers are vicariously liable for acts of employee in course of employer's business. Now what does the word vicariously liable means? If you are an employee of the company and during your course of employment, if you have done something wrong, then your employer can be held liable. That is what vicariously liable means. Clear? If so, it basically means that for self-employed person, employer is not vicariously liable, but for employee, employer is. Okay. So that is why differentiation is necessary. Next is employee get preference in insolvency of the company as compared to self-employed. When your company is shut down, when your company is liquidated, wound up, then when the assets are distributed, employers will get the payment first and the self-employed will get payment later. So in order of distribution of the assets, employee come first. Okay. Employees come first, they will be paid first, and then the self-employed. So that's the benefit. Employees receive net pay after tax and insurance deduction. Self-employed are taxed under trading income provisions. Employees receive net pay, their deduction is made from their gross salary, while for the self-employed, they have to pay the tax according to the trading income provision. Okay. Certain state benefits like statutory sick pay are only available to employees. So there are some benefits like, let's say when employee is sick, he can get a statutory sick pay while self-employed cannot. So these are the reasons why it is important to distinct between employee and self-employed. Any question you want to ask? Okay. Now let's read some cases and to get a better idea. Okay, so this is the first case, Ready Mix Concrete Limited versus Minister of the Pensions and National Insurance and other. Now, what is the fact of the cases? The cases, they are not tested in exam. Okay, so they are just
Okay.
for if
Understand.
just for understanding and your concept. It will get better when you will read the cases. Now, let's read the case. The driver of a lorry had a contract with a company under which he drove his lorry only in company's business, obeyed instructions of foreman, and wore company colors. He provided his own lorry, the equipment was his own, which he had obtained from the company on hire purchase and which was painted in company colors. He could employ a substitute driver. He was paid on the basis of mileage and quantity of goods delivered. So payment was irregular, not a fixed payment. He paid expenses of repair and maintenance of the lorry and his own national insurance and income tax. So the expenses he's bearing on his own. Minister of Pension claimed that he was an employee and the company had therefore to make the employer's national insurance contribution. Now you have done the tax paper, right? Taxation exam. And
Okay.
you know that your employer have to make a payment, the pension contribution or the insurance contribution on behalf of employee, right? So in this
Okay.
situation, the minister of minister of the pension, they claimed that this person who was driving the lorry, he is an employee, so the company have to make the his national insurance contribution. The employer have to pay the national insurance contribution of this employee to the Ministry of Pensions. So the decision here for the judge to make was that whether this person is an employee or not. If he is an employee, then obviously the company have to pay the contribution. If it's not, then it's not necessary for the company to pay that. Okay. So now, what do you think? What do you think? There are different factors. Now he was doing the work only on the company business first. He was
Yeah.
obeying the instruction of the foreman. Uniform was of company. Then equipment was his own. Equipment was his own. He could hire helpers. He was paid irregularly. He was bearing all his own expenses. So what do you think? Is he an employee or self-employed?
He should be treated as self-employed.
Yes. There are some factors that indicate that he can be an employee. But if we look at overall factors, multiple factors, then, according to the economic reality test, it is indicating that he is, more of a independent contractor, self-employed. Okay. So he was
Yeah.
self-employed. Now, what did the court said, the judge said, what was the decision? Although the employer exercised some control over his work, the other factors were not consistent with there being a contract of service. Contract of service is, basically the employee's contract. So the court said that, yes, the foreman, the company was exercising some type of control, but the other factors, they were not consistent with, with that this person is an employee. In particular, the
Yeah.
fact that he has owned his own equipment and was operating at his own risk to a degree, means that he was an independent contractor. So more of the factors were indicating that he is a self-employed person, independent contractor. Clear?
Yeah. Yeah.
Now, there's another case regarding the control test. An example of this test in operation, which may be seen in Walker versus Crystal Palace football, in which it was decided that a professional footballer was an employee of his club on the basis that he was subject to control in relation to his training, discipline, and method of the play. So, this case is old case, 1910 case. In 1910, the professional footballer, he was declared as an employee. We just talk about that according to the control test, a professional person cannot be, the control test is invalid for the professional person, right? Because uh, uh, company cannot, or the club cannot guide him how to do things, right? He know that he's a professional. So in 1910 it was declared that this person was an employee. But with developing technologies and specialization, the control test become inappropriate, as employers would hire people for particular skills of which employer did not have a sufficient knowledge or skill to instruct as to manner in which they carried out their work. So with time, update in time and technology and specialization, the control test, it became inappropriate for professional peoples or skilled workers. Because the skilled workers, they know how to do things, right? Employer do not have to instruct them how to do things. So that is why for the professional workers and the skilled workers, control test is invalid now. Okay. Now this next case, integration test. It is about integration test. An example of an application of integration test may be seen in Whittaker versus Minister of the Pension National Insurance Contribution National Insurance, in which the court found out that degree to which a circus trapeze artist was required to do other general tasks in relation to the operation of the circus in which she appeared indicated that she was an employee rather than self-employed. As a consequence, she was entitled to claim compensation for injuries sustained in course of her employment. So basically, the case here was that the circus trapeze artist, the artist who perform in the circus, he basically, what was his job? His job was to do the stunts plus doing the administrative work. So this was the role of the trapeze artist. Now what happened was that this trapeze artist, while she was performing stunt, she got injured. And when she got injured, she claimed compensation from the company by saying that I am an employee. Okay. Now the company said that you are not an employee. So now the court had to interfere, and now it was decided that on the basis of integration test, this this artist, he was doing stunts plus administrative work. Now the stunts in a circus, it's a integral part of the business, right? The doing stunts in an circus, it is an integral part of business, right? Plus he was also doing administrative work. So it means that the task that she was doing, it was an integral part of the company or the circus. So she will be an employee of the company rather than self-employed. So she was entitled to claim for compensation. Got the case?
Yeah.
Now there's another case that is regarding the economic reality test. A market research interviewer worked on and off under a series of contracts whereby she interviewed for a company in accordance with interview instruction issued by a company. She had to complete the work within a specified period, but otherwise had no specified hours of work. There was no provision for holiday or sick pay, and she was free to work for others while working for the company. So now the decision is whether she was the whether she was an employee or not. Now in the book the facts are not uh, mentioned in detail. When I researched the case, it was written that in term of contract, the term of contract were strictly followed. She was entitled to follow the terms of the contract strictly. Terms of the contract. Now, what were the terms of the contract? Term of the contract stated that this is how she should interview, what should be the subject for interviews. All the things was specifically guided to her by his employer. Okay. Now the thing is whether now we have to decide whether she is an employee or an self-employed. So what did the court said? The company did have some control over the manner in which she did work for the terms of the contract were consistent with contract of service. The court emphasized that she did not provide her own tools and took no risk. Now look at the decision of the judge carefully. The court said that yes, her working hours were irregular. Yes, her working hours were irregular. Okay, so this is indicating that she can be a self-employed person. But the factors that they look at is that she did not provide her own tools and she had to bear no risk. If let's say she was an interviewer and she selected some employee who was not capable, So who is the so the loss will be paid by who? Company, right? So the loss is of the company. She was therefore not in business on her own account and was an employee and not an independent contractor. The court also emphasized that there was no exhaustive test compiled, no strict rules laid down as to the factors which identified a contract of service. So this is what the court said, that she is a employee. Why? Because uh, she was declared an employee. Why? Because she did not provide her. No, okay, I think she was declared. Yes, yes, she was
No,
declared
this,
as an employee. Yes, she was declared an employee. Okay. So what were the factors that the court emphasizes? Number one, that she did not provide her own tool. She did not took any risk. The risk was all
this,
bear by the company. So she was not in on business or on own account. So she was not an independent contractor. Okay, clear? Now what about temporary or casual workers? Now let's read this case. And a wine waiter was called a regular casual because he was given work when it was required in the banqueting hall. He had no other employment, and it was generally accepted that he would be offered work in preference to others when work was available, and that he would accept such work when offered. So, what do you think? Is he an employee or
especially,
self-employed? What do you think?
I think myself,
Self-employed. The reason is that he was casual. The thing is, yes, company gave him preference, but he was not obliged to do the work, right? It was not any contracted work. So, it was
no,
up
it's,
to him. Yes, he usually
yeah,
accepted the work, but it was up to him, to accept or not, right? So that is why
yeah,
he was declared an independent contractor, because there was no mutuality of obligation. In that, company was under no duty to offer him work. Now mutuality of obligation was that employer will offer him work. There's a duty of employer to offer him work, and he have the duty to accept it. But it was not in that case. Yes, he was given preference, but he was not bound to accept the work, right?
yeah.
However, when
Also,
at
he
work
has
he
no issues.
Yes. However, when at work he wore company uniform, did not use his own equipment, did not share in the profit, and had no investment in the business, it these are other factors that they have had. These factors kind of indicate that he can be an employee, right? But the
Yeah,
main thing that the court said is that because there was no mutuality of obligation, and he was under no duty to accept that, and company was not under no duty to give him the work at any cost. So this is what the reason was presented, and it was declared that he was an self-employed person. Okay. Then home workers or out workers. There are also problems with home workers or out workers. Generally, such people will be paid by number of the pieces they produce and will supply their own equipment. Their position is ambiguous, which means unclear, and many consider themselves to be self-employed. But the law does not always take this view. Home workers or out workers basically are the people who are working from home. Their job is to pay to produce the products, and then they transfer the products to the company. And usually they have their own equipment. So usually they are declared self-employed, but it is not necessary that in every situation they can be self-employed. Now let's read a case here. Two women, two women who sew trousers at home let the company know when to deliver material and collect finished garments. They rarely refuse work, but did give warning if they did not want it. Like, for example, going on holiday. They submitted time sheets and were paid at same rate as the workers in factory. Company relied on the work they produce. The company provided the machines. So what will they be? They will be considered as employees. There are multiple reasons. Number one reason is that who is providing them with the material? Company. Who is providing them with tool? Company. Company is giving them same rate as they are giving their workers. They are also submitting time sheets. Plus, the company is relying on their work. So it means that they will be considered as employee. Okay. And there was also mutuality of obligations. Why? Because they really refuse work. So it means when the company now There is a duty of the company to give them work, right? Why? Because company are relying on the work they produce. So if I am relying on someone, I will keep that person happy, right? I will give him the work, right? So there is a mutuality of obligation. So they were declared employees. Clear? Okay. Now let's move on to the next topic, that is contract of employment. Okay. So contract of employment consists of three things. Express terms means what the terms that are mentioned in an agreement and expressly mentioned in an agreement, those are known as express terms. Like for example, if I am an employee, and when I will apply, let's say I want to apply for the job in your company, and when you will hire me, we will have an employment contract. In that contract, the terms that we expressly agreed will be known as express terms. Then terms implied by court. This means that these terms are not written in the contract of employment, but they are applicable because they are implied by court. Similarly, terms implied by statute, which means law. So the terms implied by law is that these are not mentioned in my contract expressly, but they still are applicable to the contract of employment because they are implied by statute. Okay, clear? This thing implied by court, implied by statute. Now, what are express terms? These are the terms that are agreed by parties themselves. Employment Right Act 1996 requires employers to must provide statement of employee particulars. Statement are principal statement and wider written statement. So express terms are basically the terms that are expressly agreed, that are mentioned in your contract of employment. And under Employment Right Act, there are certain statements that an employer have to submit. Now, what are those statements? There are two statements: principal statement and wider written statement. Now, this is what an employer need to submit. Okay. Now, what is principal statement? Can you please read it loud?
Name of the employee, the employee's name,
No, the
job
first
title,
line is the principal statement must be provided
be
on
provided
first day of
the first
employment.
day
Yes.
employment and include his name of the employer, the
Yes.
employee's name, job title or description of the work and start date, how much pay and how often,
Yes.
hours of work, if and how they may vary, working Sundays, nights, or overtime, holiday entitlement, place of work, how long a job expected to last, and the end date if fixed term contract, any probation period and condition of probation, any other benefits, example, childcare vouchers, obligatory training, whether or not paid for by the employer. Other information must be provided on the first day of employment. Sick leave and sick pay entitlement, other paid leave, maternity or paternity leave, length of notice of termination on either
Either
side.
side. So this statement must be provided to the employee by employer on first day. Okay. Is
Okay.
legally required to do that. And there was another statement that is known as wider written statement, and it must be provided within 2 months of the start of the employment. And what does this statement contain? What is the information that this statement contain? Pension arrangements, if there are any.
Okay.
Notice period, if an employer wants to fire you, so he must submit you, he must deliver you some notice period. So what is that notice period? It should be mentioned. Collective agreements. Now, in an organizations there are trade unions. Trade union means there's a union of an employees who are responsible for fighting for rights of an employee. Like, let's say for example, if an organization is not paying sufficient amount to employees, then the union of an employees, they can claim, they can ask, or they can request, or they can have discussion, they can have argument with the employer, that we should be paid, this we should be paid a correct amount. So this is known as collective agreements. It's like kind of trade union. Okay. You know what trade union is? The word trade union.
Yeah. Yeah.
Yes. So basically, union of employees. So in wider written statement, it must be mentioned that, if there is an any collective agreement, or if you want to be part of a trade union, this is where you should go, or you have to let the employee know that this is a trade union. in which you can participate and you can collectively decide about the things. So it should be mentioned in wider written statement. Any right to non-compulsory training provided by employer, it should also be mentioned in wider written statement. And disciplinary and grievance handling procedure. This means that grievance basically means if you are not happy. So if an employee is not happy, what is the procedure? Where should he go? If there's a dispute, in case of a problem, where should an employee go? So this is also will this thing will also be mentioned in wider written statement. Okay, that if an employee, if you are not happy, let's say the wider written statement will be provided to me, I am an employee, so it will be mentioned that if I am not happy with something, if I have a problem with something, this is how I have to deal with that. What is the procedure for that? That is mentioned in the wider written statement. Okay, clear? Principal statement, you have to provide that, employer have to provide that on first day, while the wider written statement must be provided within 2 months. Okay, terms implied by a code. Now the thing is, the statement is this, these statements are not a contract. That's, the things that are mentioned in the statement, these are not like kind of a contract, but this is how the contract will look like. In the contract these things will be mentioned. Okay, so it's
We
not
have
a
signed
contract.
that document, right? When we get that document, we have to sign and agree.
Yes, this is a document in which the details will be mentioned of everything.
Yeah, but the employee have to sign that document, right?
Yes, he can,
And
it is just for his information. If he's agree with that, the let's say for example, if you are going to an employment, you have a probation period, right, for some time,
yeah,
and then the final contract is offered for you, right, offered to you. So in the principal statement, these things will be mentioned when you are going to
yeah,
do the probation, right, on the, or when you are on probation period. So let's say after the probation, if you are agree with you if you are agreeing with all the terms on principal statement, then you can say, then this statement can also become a contract. It means the contract will kind of look like this principal statement, but it is not a contract. Okay, contract is
okay.
what you will agree, the agreement that you will make. Terms implied by code. This means these terms are what? The thing is, when you are doing the contract, there is an express agreement. There are some express terms in agreement which are specifically mentioned. You have mentioned that, the employer employee, they know these are the terms. They have expressly identified those terms on contracts of employment. Now, terms implied by code are that those terms which are not mentioned, which cannot be mentioned in the contract, but they are still applicable. So under the terms implied by the code, there are some duties of an employer and there are some duties of employee. Now, what are the duties of employer? The principal duties of employer are strictly imposed and include the following: to provide reasonable remuneration. This means that an employer should provide a reasonable amount of salary to his employee. Okay, to comply with the law relating to the working hours, average weekly working hours must be limited to 48. That maximum work that a person can do weekly should be 48. To provide a detailed pay slip, an employer should provide a detailed pay slip to an employee in which it should be mentioned that this was, the gross pay, and these were the deductions, and this is the net pay that you will get. To indemnify employees for expenses incurred in course of the business. Indemnify means reimbursing. If an employee has spent some money from his own pocket regarding the business activity, then it is a duty of an employer to indemnify him, to reimburse him that amount. To take reasonable care for employees' health and safety. It is a job, it is a duty of an employer to provide a safe system of work, to provide a safe system of the work to employees. Reasonable care means, there should be a reasonable safe system, right? It's not that it will be 100% safe. There should be reasonable care. Okay, to provide appropriate training, to provide the training to the employee, to ensure mutual cooperation and respect, and that you have to behave in a certain manner, right? Because there's a relationship of trust and confidence. You should not be indulge in arguing and this stuff. You have to behave in a certain manner. To give reasonable notice of termination of the contract. If he is going to terminate your contract, if he's going to dismiss you, employer should provide a reasonable notice to employee. Provide a reasonable amount of work. Sufficient work must be provided to employee. Like for example, in F2 exam, there was a piecework system in which employees are paid according to the number of units they are producing. So let's say on a certain day there is no work available, then employee will get nothing, right? He will get zero. So it is
Yeah.
a job for an employer to provide him with the sufficient amount of work. So these are the duties of an employer that are implied by the court. Clear?
Yeah.
There are some duties of an employee as well. What are those duties? To obey lawful and reasonable orders. To obey all the lawful and reasonable orders of an employer, it is a duty of employee. Exercise reasonable care and skill while doing the work. It is a job of an employee to exercise reasonable care and skill while he's performing work. He should not be negligent, he should be not negligent with regard to his work. So he should do his work in a right way, in a right manner. Give honest and faithful service. It is a duty of an employee to give an honest and faithful service, to maintain the trust and confidence of an employee. How, what is the duty of honest and faithful service? Like for example, he should not misuse any of employees properties, and he should not take the business things with him in on his home, on his in his home, like for example stationary thing and all this stuff, or assets of the company. He cannot do that. So his duty is to give honest and faithful service. Duty to give personal service, not delegate work to other without permission. If an employer has gave you the work, it is your job to do that work. You cannot delegate that work to someone else without the permission of employer. Not to disclose or misuse the confidential information. This duty is implied even after employment ceases. Very important. It is a duty of an employee not to misuse the confidential information. Okay, confidential information. This duty is implied even after employment ceases. Even after your employment is terminated, it is over, still it is your duty not to provide a confidential information of the previous company to someone else. Regarding this, there's a case in your book as well, in which there were two employees of the company, and the job of the company was to manufacturing the hearing aids for for the people who cannot hear, hearing devices. Now those two
Yeah.
employees, when they left the company, they joined some other company and they give the confidential information. They disclose the information of the previous company to the next company. So when the previous company got to know about that, that company basically sued the other company, and the injunction was granted. The court said that the company, the employees who have given the confidential information to the latter company, that company cannot now make those devices. Injunction was granted. They cannot do that. Okay,
Police. Yeah.
clear?
Yeah.
Now there are
Yeah.
terms, some certain terms employed by certain law. Now, what are those terms? Under the Employment Right Act 1996, it gives employees certain rights, such as a right not to be unfairly dismissed. It is a right of an employee not to be unfairly dismissed, a right to redundancy payment if he is made redundant, and a right to minimum period of the notice to terminate the contract. So these are the rights given to employee under the law Employment Right Act 1996. Under the Working Time Regulation Act 1998, the maximum work that an employee can do, it should be average 48 hours a week. Employee should be provided with 4 weeks paid leave for a year, and he should be given off for at least one day each week. Okay. Now these terms may
Police.
not be agreed in the contract, in the employment contract, but
Yeah.
they are still valid for the contract. Okay.
So 4 weeks early is like applicable for all the people in the UK, people who work
Yes, yes, 4 weeks applicable. Yes, paid leave for everyone who works in the
early.
UK.
Yeah.
For
That's
obviously
great.
full-time employment. Employment Act 2002 states it gives parent of the children under 17 or disabled children under 18 the right to request flexible working arrangements. The employer must give serious consideration to such a request and can only reject it for clear business reasons. The Act also introduced paternity and adoption leave. The Employment Act 2002 states that if the parents whose children are young, whose age is under 17, or whose children are disabled, and if they are requesting the employer for a flexible working arrangements, And if it is possible, then employers should provide them with that flexible working hours. Okay. And this act also introduced paternity and adoption leave as well. So under this act, this act is latest, like in 2002 it was created. You know what paternity leave is, right?
Yeah.
Okay. Paternity leave is for employees and maternity, oh, sorry, for male employees, and maternity for the female. Equality Act 2010. It deals with protecting people from discrimination in workplace, recognizes protected characteristics in terms of remuneration, deals not only with pay but other terms like holiday and sick leave, implies an equality clause into all contracts of employment if workers of opposite sex do the same job or a different job of equal value. Under the Equality Act 2010, uh, you know, this act states that you cannot discriminate any employee on the basis of the caste, religion. You cannot discriminate them. And this act also implied a equality clause in all of the employment contract. What is equality clause? That whether a person is a male person or whether she is a female, they should be provided with an equal pay. If they are doing same job or the job of equal value, then the pay should be same. And the National Minimum Wage Act 1998 states that there should be at least minimum level of the pay imposed for employee. Okay, there should be a minimum wage, whether it is a daily wage, whether it is a weekly wage, monthly wage. There should be a minimum, okay, amount. So these are the terms implied by statute. Any question you want to ask? Okay. Now, next thing is termination of the contract. We talked about the contract of employment. Now, how a contract is ended, termination of the contract. An employee's contract of employment is terminated if employee terminates it on the notice or breach the contract, or employee is dismissed by employer. Now, how a contract is terminated? If the employee terminates it, cancel the contract, and serves the notice that I am going to leave the company, then the contract will be terminated. Or if he breach the contract, if an employee breach the contract, break the contract, then the contract will be terminated. Or the employee is dismissed by an employer. Employer has dismissed the employee from the company, so it means the contract is terminated. Now, what does the word dismissal means? Now, dismissal is contract is terminated by employer with or without notice. If the contract is terminated by an employer with or without notice, we will say that this is a dismissal. We will talk about different types of dismissal in few minutes. Expiry of fixed term of the contract and it's not renewed. So there was a fixed term of the contract, and if it is not renewed, then we will say that that employee is considered dismissed. Employee terminates the contract with or without notice by reason of employer's unfair conduct. Employee himself resigns, terminates the contract, resigns with or without notice. Why? Because he was not happy with the conduct of employer. So then he will also be considered as dismissed. Every employee has a right not to be unfairly dismissed. Every employee has a right that he should not be unfairly dismissed. Notice period are usually mentioned in the contract of employment, but if not, ERA Employment Right Act specifies minimum notice period. So usually, you can agree with the notice period in your contract of employment. But if they are not mentioned, that these are what notice period which will be applicable. For an employer who has worked for 1 month up to 2 years in a company, the notice period served to him by the employer should be at least 1 week. Okay. If an employee is working for, let's say, for 2 to 12 years in a certain company, then employer have to give him the notice of 1 week per year. So let's say if he has worked for 5 years, 5 week notice should be given by employer. He cannot dismiss him on spot. He have to give him five weeks notice. Okay. If he has worked for 10 years, the notice period should be 10 weeks. Clear? If an employee has worked for more than 12 years, then the maximum notice period, it will be of 12 weeks. Okay. From an employee point of view, if an employee has worked for at least 1 month in a company, he can serve a notice period of 1 week. Employee can serve a notice period. Okay. Now the maximum amount, it is stated in the contract of employment. Clear?
Yeah.
Now types of the dismissal. Now this is interesting and important. Summary dismissal. Dismissal without notice is known as summary dismissal. If your employer has dismissed you, fired you, sacked you on the spot without giving you the notice, this will be known as summary dismissal. It may be justified because of the conduct of employee was such that prevented continuance of employment. For example, employee may have been dishonest, incompetent, negligent, immoral. Summary dismissal can be justified if the employee's conduct was not good. Like if he was dishonest, incompetent, negligent, immoral, then these may be the right reason to summarily dismiss him. Okay. But if the summary dismissal was not justified, then employee have a case for wrongful or unfair dismissal. If the summary dismissal was not justified, then employee can put a claim against the company for either wrongful dismissal or unfair dismissal. Okay, he can put a claim in any of the case, like for the wrongful dismissal or unfair dismissal. Compensation of an amount equal to what you would have earned. Okay, this is another important thing. uh, Payment in lieu of the notice. This is now this point states, okay, compensation of an amount equal to what you would have earned during notice period. Like for example, let's say that on 1st March 2024, your employer dismiss you without notice. So they dismiss you without notice, then it is known as summary dismissal. Now let's say that the reason behind the dismissal was not justified. Okay, the reason behind the dismissal was not justified. Another option for an employee is, one option is that that he can put a claim and he can fight a case for wrongful or unfair dismissal. Another option for him is that he can claim compensation. I will write it down here. Claim compensation. Or employee can claim compensation of an amount equal to what you would have earned during notice period. Other option is that employee will say that, okay, you dismiss me without notice, and if you would have served me the notice should have been of, let's say, 6 weeks. Okay, so the employee will say to the employer, if you can if you will give me the pay of these 6 weeks, I will not bring the charges against you. So this is another option that is given, that an employee can also exercise. Okay, clear?
So 6 weeks is like a standard amount, or is it like it's up to the
Whatever
employer?
the salary he was, if he had worked for the six
Okay.
weeks, this thing is
No,
known as payment in lieu of
I
the
mean,
notice.
I
Yes.
mean the 6 week is like a standardized time,
No,
or
it
is
can be
like
different. It can be different. Like for
different,
example,
right?
the notice period was, let's say, if employer had dismissed you, and the notice that he should have served was 2 weeks, then you can claim the 2 weeks amount from him. You can say that,
Okay.
you
It's
just
it's
give me, yes, you just give me the compensation for the 2 weeks. I will not bring the case against you. Simple.
it depends on the notice period, right? Notice period given by the employer.
Employer, yes, the employer, haven't given you any, employer, not employee, employer,
Yeah, yeah,
because
employer.
employer has dismissed you, right? So the thing is,
Yeah.
it is not decided by employee. But the thing is, if, let's say, employer would have dismissed you for right reasons, the notice period that should be served, that will be considered as a standard notice period, of which you are entitled to get compensation if you don't want to bring forward the charges against the company. Okay. So if an employee is summarily dismissed without justifiable reason, then he can either put a claim against the company for wrongful or unfair dismissal, or he can claim the compensation for an amount equal to what he would have earned during the notice period. Okay. Then comes the wrongful dismissal. Wrongful dismissal is available to both employees and self-employed, and unfair dismissal is only available for employees. Now, what is wrongful dismissal? Wrongful dismissal occurs where employers terminate the contract without giving proper notice or during its fixed term. When an employer terminates your contract without giving you the notice or during the fixed term, then we will say that he has wrongfully dismissed you. Okay. So A summary dismissal can also be a wrongful dismissal, right? Because let's say he has dismissed you without giving you the notice, then it means that is also summary dismissal, right? So wrongful dismissal or summary dismissal can be a wrongful dismissal as well. Employee can bring civil law action against employer for compensation in employment tribunal, provided he does that within 3 months of dismissal and claim is for £25,000 or less. Now, if you are wrongfully dismissed, if you are dismissed without notice, or if you were dismissed during your fixed term of the contract, the contract term was of 2 years and you were dismissed after 1 year, then it also means that you are wrongfully dismissed. Okay. Now, what options are available to you? You can bring the case against an employer for compensation in employment tribunal, and you have to bring forward the case within 3 months of dismissal. And if the claim is for £25,000 or less, then you have to, and if let's say the claim is for more amount, then you can go to high court as well. Okay. So if the claim is for less than £25,000 within 3 months, you can go to the employment tribunal and you can bring the charges against your employer for wrongful dismissal. Clear?
Good.
Next comes the unfair dismissal. Now, the wrongful dismissal is available for both employee and self-employed, but unfair dismissal, only the employee have the right for unfair dismissal. Now, what is unfair dismissal? When employer terminate the contract without justifiable reason, it is known as unfair dismissal. When employer breaks your contract without giving you any right reason, then it is known as unfair dismissal. This is a statutory right under Employment Right Act 1996. Only employees can bring an action for unfair dismissal. This is a statutory right that is given to employees. Now, what is the procedure of unfair dismissal? And if you are, let's say, if it was not justified, then what are the compensations? Now, let's read that. Now, very important point. Uh, must be continuously employed for 2 years. If a person wants to get any compensation in regard to unfair dismissal, then that person, he should be continuously employed for 2 years in the company. Okay. If let's say, what do you mean by the continuously employed? That he was part of an organization for 2 years. Now the leaves, we will not exclude the leaves. Like for example, if there was a lady, she got maternity leave of 3 months, so still that leave will be there in the continuous employment term. Okay. So the employee must be continuously employed for 2 years. Clear? Hello, can you hear me?
Yeah. Yeah.
Okay. Must serve grievance notice on employer. We just talk about that, that in the statement, the violator statement, it is mentioned that how to, if you are not happy with something, where can you go and serve the grievance notice, who you have to reach. So an employee must serve the grievance notice on employer. Claim to employment tribunal within 3 months of dismissal. Claim to employment tribunal, within 3 months. Put a claim against the employer. Employee must prove that they were dismissed, and employer must prove reason for dismissal. Employer must prove that it is within one or more of the 5 statutory fair reasons. Employee should prove that they were unfairly dismissed, and employer should prove that they were fairly dismissed. Okay. Now, what are the 5 reasons that are considered as fair reasons to dismiss an employee? So, if an employer is dismissing the employee for these 5 reasons, then they are right reasons. Okay. But except for these 5 reasons, he cannot dismiss you. Those will not be the justifiable reasons. Now, what are those reasons? The first one is capabilities and qualification. If you are not capable of doing work, or if you are not qualified enough to do work, then your employer can dismiss you. First reason. That's a fair reason. Second is conduct of an employee. If the conduct of an employee is not good, he's misbehaving, he's lying, he's fighting, arguing, then that is a fair reason to dismiss him. Redundancy, we will talk about that when, let's say, you are running a restaurant chain and you have 3 restaurants. Now let's say you want to shut down one restaurant. Now when you will shut down one restaurant, it means, all of the employees, they have to leave the organization, right? They have to leave that place. So they will be known as redundant. This is known as redundancy. Okay. Then another reason is continued employment will contravene statute. That if the employee will continue his employment, then the law is contravened. Contravened law is getting, you are breaking the law. Now, what does this mean? Like, for example, there's an employee who was involved in a criminal proceedings, and he is working with you as well, right? So because he's involved in the criminal proceedings, he cannot work with you. You have to dismiss him, because if he will continue the employment, he is also the criminal. Then you are contravening the statute as well. Okay. And some other substantial reasons, some other significant major reasons, which are right one to dismiss an employee. So you can, these are the fair reasons for the dismissal. If an employer has will if employer proved that I have dismissed an employee or on the basis of a fair reason, then employee will not get compensation. So employee have to prove that he was unfairly dismissed. The tribunal must be satisfied that employer has acted reasonably. Now, what does this point mean? The tribunal should be satisfied that that employer has acted reasonably. Employer, what does this mean? Like, for example, if employer says that the employee was not capable, so it's not that if let's say employee make a mistake, then you just fire him. No, the employer should act reasonably. First he should give employee fair warning. He should give employee opportunity to recover or cover up his mistakes. It's not that, like, if you made one mistake and he will just fire you. No. So he should act reasonable. Okay. Conduct, let's say if your conduct, let's say the employer is saying that employee conduct is not good, then the thing is, it if let's say if he has done something wrong, first you should give him fair opportunity to cover up his mistake. Fair opportunity, to give him fair opportunity, that he should not make mistake in the future. It's not that if he did one thing wrong and you had fired him. No. So employer should act reasonably. Okay. Got the point?
Yeah.
If found unfair, entitlement, reinstatement, re-engagement, or compensation. If let's say it was found out that you are the employee was unfairly dismissed, then he is entitled to either getting reinstatement. Reinstatement means getting the same job back. Re-engagement, not getting the same job but kind of identical job back. Or compensation. So he is entitled to these three things. He can be reinstated, he can be re-engaged, or you have to compensate him. Got the point?
Yeah.
Now, what is the compensation? Let's see. These are the awards. First one is basic award plus compensatory award plus any additional reward. So basic award means that this is the award that you will get. Okay. And compensatory means plus you can get some additional award as well. Compensation for you, compensatory amount, plus another award as well. So there are three types of the award that can be offered to a person who is unfairly dismissed. But the thing is, first you can offer him reinstatement and re-engagement. If let's say employer is employee, because the relationship now with an employer is not good. So if employee feels that I will not be able to I will not be able to work with that employer again, then there is no point of reinstatement and re-engagement, right? Because it's not practically possible, because they are not happy with each other. So in that case, the awards will be the employee will be rewarded by these awards. Now, what is the award? The first one is basic award. If an employee is 18 to 21 years of age, he will get half week's pay for each year of the service. Let's say weekly pay is, let's say, $100. An employee, let's say, worked for 4 years, or you can say, let's say, 3 years. If an employee worked for 3 years, and his age was in between 18 to 21. Then how much he is entitled to? Half weeks pay for each year of the service. He gave the service for 3 years. Weekly pay is 100. Half weekly pay is 50. So for 3 years, his basic award will be 50 times 3, 150. Clear? This is the basic award that he will get. For an employee whose age is 22 to 40 years, then he will get 1 week pay for each year of the service. Now, let's say an employee worked for 5 years and his age is in between 22 to 40, and assume that weekly pays $100 per week. Then how much will he get? 5 times 100, that is 500. So this is his basic reward. Got it? And if the age is 41 plus, then 1.5 weeks pay for each year of the service. And the maximum is, if let's say if a person has done 20 years service for an organization, then he will get 571 pounds a week. Okay. Then in that case, you will not look at his weekly pay. You will give him 571 pounds per week. So if he has worked for, let's say, 20 years, so the basic award that he will get is 571 times 20, that is 11,420. Okay. So this is the basic award. Then comes compensatory award. Discretionary award of up to 93,878 pounds based on employees' losses and expenses, reduced if the complainant contributed to their dismissal. Now, this is the basic award that you will get at all cost. Compensatory awards are the awards that depends upon the judges. Like, for example, if you were unfairly dismissed and because of that, your losses were increased and you have to bear more expenses, then you can get some additional award, okay, from judge. Those are known as compensatory award that will compensate for your losses. Now these compensatory award can be up to 93,878 pounds. Like for example, if a certain case, your expenses or losses was, let's say, 1,000 pounds, then you will be compensated with 1,000 pounds in addition to basic award. So this award, compensatory award, can be up to the maximum of 93,000 pounds 878. Obviously, it will depend upon the case, right? Different cases will have the different compensatory awards. Okay, got this point? Reduce if the complainant contributed to their dismissal. If the complainant themselves contributed to their dismissal, then this award will be reduced. Let's say employee also made some mistakes, then the awards can be reduced. Additional award, then you can get some additional award as well. When employer ignores an order for reinstatement or re-engagement, let's say you are ready to get back into the company, but your employer ignored this, then he have to pay you some extra as well. The dismissal is unfair because of the race, sex, or disability discrimination. So because of these reasons, you were fired, you were unfairly dismissed, then you have to pay, the employer have to pay you something extra in addition to basic and compensatory. The reason cited for dismissal is an inadmissible one. You were dismissed for an inadmissible reason, not a fair reason, then you are entitled to additional award as well. Okay. Now, what is inadmissible reasons? What are, okay, let's read what are inadmissible reasons. Okay, it's not there. Just a second. These are inadmissible reasons. Please, okay. If you are dismissed for one of these reasons, then you can get additional award as well, and you will be considered as unfair dismissal. Okay, you will be considered as unfair dismissed. Now, what are the reasons? Victimization of health and safety complainants or whistleblowers. A whistleblower is a person who raises a concern about wrongdoing occurring in an organization. The revealed misconduct may be classified in many ways. For example, violation of the law, rule, regulation, direct threat to public interest such as fraud, health, safety violation, and corruption. Now, if in your organization there was an employee who was not happy with the working environment, health and safety environment, and who was not happy with the practices, the corrupt practices that were going on to the company, and if if he put up the case against you and you victimize him. You know what whistleblower is? Whistleblower is basically a person who feels unhappy in an organization, and who raises a concern about wrong practices of an organization. So if a person is raising a concern about the wrong practice of an organization, and if an employer is victimizing him, if he's putting a pressure on him, he's giving him threat, then then this is an inadmissible reason for dismissing him. And if the employer does so, then the employee will be entitled to additional award as well. Okay. Pregnancy or exercise of maternity leave rights. If you are dismissing your employee, female employee, because that he is now pregnant and he will get maternity leave for 3 months, 4 months, so I'm dismissing him. If you will do this, this is an inadmissible reason, and you have to pay additional reward to that employee as well. Okay. Trade union membership, non-membership activities. If your employee is a part of a trade union, and because of that, you want to, you are dismissing him, that, why are you part of that union? Why? Because that union is raising concerns against the company. You cannot, dismiss him for this reason. Assertion of a statutory right, like for example, exercise of paternity leave right. If your employer is not giving you the rights, statutory rights, and you are forcing him to give the statutory rights, and he dismissed you, then that is an inadmissible reason. And if it happens so, you are unfairly dismissed, then you are entitled to additional award as well, in addition to basic and compensatory. Unfair selection for redundancy. We will just talk about the redundancy as well. If you were made redundant, but you were unfairly selected for that procedure, then that's also an inadmissible reason, and you are entitled to additional award. Clear? Now, the last type of the dismissal is constructive dismissal. Employee terminates the contract with or without notice in circumstances which are such that she is entitled to terminate it without notice by the reason of an employer conduct. This is known as constructive dismissal. We just talk about the wrongful, unfair dismissal, summary dismissal. In those cases, who is dismissing you? Employer, right? In constructive dismissal, you yourself are resigning. Why? Because of the conduct of your employer. So you will be still considered as dismissed, constructively dismissed. Now, what are the conducts of the employer that can let you, make a decision of resigning? The first one is putting undue pressure. The employer is putting undue pressure on you. The employer is putting, more pressure on you to do the work, not to do the work, or putting or exercising or asserting more pressure on you. Demoting you without any reason. He's demoting you from your position without any reason. He's, he's reducing your payment. He's harassing you. He's bullying you. He is breaching term of the contract. If an employer is breaching the term of the contract, then in that situation where the employer conduct is such that you are not happy with what's going on, then you can resign. You can resign yourself and bring an action of constructive dismissal against the employer. Okay. An employee must prove that employer action have fundamentally breached the contract. Employee should prove that, because of his action, the contract was breached, and that's why she resigned, or she or he resigned. An employee who is constructively dismissed may seek remedies for wrongful or unfair dismissal as appropriate. So if you are constructively dismissed, you can put up a claim of the wrongful dismissal or unfair dismissal as well. More chances are that, you will put a claim of unfair dismissal if you are constructively dismissed. If employee don't resign in event of breach, he is deemed to have accepted breach. However, he don't need to resign immediately and may wait until he has found another job. That is very important point. Like, let's say, for example, let's say today is 1st March, and on 1st March, you are observing that, your employer is putting undue pressure on you. He is, kind of harassing you. He's reducing your payment. And this thing is happening for, let's say, for 10 days, 15 days, 20 days. And this thing is, let's say, for happening for now 3 months. So if your employer is, is the employer has not, if your employer is not doing right conduct, he's not, doing right conduct, he is harassing you, bullying you, and this is happening for 3 months. So the court will assume that, you have accepted his breach. You are okay with what he's doing. Got the point?
Yeah.
So it means, when and your employer is harassing you, when your employer is, demoting you, he's giving you less payment, he's putting pressure on you, then you have to resign, in a reasonable amount of time. You don't have to wait for a longer period of time. However, he don't need to resign immediately and may wait until he has found another job. It's not that, if he's harassing you or bullying you on like it's first day and you have resigned. No, the court says that, look for 5 to 6 days, 7 days, 10 days, and if the things keeps on going, then apply for another job without letting him know. And when you found out another job, when you have found another suitable job, then you can resign and put a claim of constructive dismissal against him. Okay. So you should, resign in a reasonable amount of time. You should constructively dismiss yourself in a reasonable amount of time. Now let's go through some cases of the constructive dismissal. Okay, so okay, now please read this case loud. Donovan versus Invicta Airways.
Yeah, facts. The employer put pressure on the employee and airline pilot to take abnormal risks on a flight. The employer did this 3 times in rapid succession. Each time, the employee refused. Relations with management deteriorated and he left.
Okay. So the employer was putting a pressure on his employee who was an airline pilot. What was the pressure? He was pressurizing him to take risk on the flight. And he did this 3 times. So when the employee refused, the relationships got bad. And because the relationship got bad, then the employee resigned and put a claim of uh, constructive dismissal against an employer. Now what did the judge said? The employer had committed serious breach of the contract amounting to constructive dismissal. The employee succeeded in an action for wrongful dismissal. So he put up the when constructively dismissal is a type of dismissal, and for that you can bring an action for either unfair or wrongful dismissal. Okay, similarly, just like summary dismissal, if you are summarily dismissed, you can put an action for either wrongful or unfair one. Okay, you are clear with this point, right?
Yeah.
So another case, please read. Okay, this is S had been employed to work on night shift. When his employer attempted to force him to work on day shift, he resigned. So there was a person who was employed, and in the contract of the employment it was mentioned that he will work on night shift, but his employer forced him to work on day shift. So the employer is breaching the term of the contract, right? So that employee, he resigned, and he put the claim against him, and he was successful in that. Okay, now another important case, a very recent one, is Kevin Keegan. I don't know whether you are football freak or not. So this is about a football club of the UK. Now, what was the case? A football club manager resigned from his position and claimed he was constructively dismissed. He contended that he was appointed manager of the club, and it was agreed that he would have the final say regarding the transfer of the players into the club. The club breached his term by signing a particular player against his express wishes. There was a football club manager, and when he did an agreement with the football club, in the agreement it was mentioned that the manager will have a final decision regarding the transfer of the players, regarding which player will come into the club. Now the club reached his term and they signed a particular player against his will. So it means that the club, which is an employer, they breached the term, right? So the manager resigned, and guess what? He got £2 million in damages. He got £2 million in damages. Kevin Keegan.
Yeah.
So that's
You must.
very interesting. Big amount. So
Yeah. But they normally paid like huge amount for just
it
mistake.
depends upon the situation of the case. Like this club manager,
Yeah.
his salary was very big, and the
Yeah.
compensation is accordingly.
Yeah.
Okay, so this we got talk about that. Okay, this is an important point as well. This please read an employer.
An employer can only rely on a given reason for dismissal where they live or peak at the date of the dismissal.
Now please read the case regarding that.
That's the employee dismissed the employee and afterwards discovered that the employee had been guilty of dishonesty.
Okay, now that
Dishon-
very very
dishon-
very interesting. The thing is, when you are dismissing someone, when an employer is dismissing someone, then if the other if an employee put up and bring an actions against an employer, then employer have to give the reasons that what was the reason, why you dismiss him at the date of the dismissal. What were the reasons at the date of the dismissal of dismissing the employee. You cannot give any reason that happened after the dismissal. Like for example, in this case, a certain employee was dismissed by an employer, and employer found out later after dismissing him that he is also guilty and dishonest. He is guilty of dishonesty. So he put up, he put this reason that, because he was guilty of dishonesty, that is why I dismissed him. But the judge says, the judge said that, this reason you were not aware at the time of the dismissal. So you cannot give that reason. Got the point?
Yeah.
So you cannot rely on any reason that happened
Okay.
after the dismissal. You have to give the reason, that what was the reason at the time of the dismissal. Because of that, you dismiss the employee. Okay. So now, okay, so last topic of this chapter is redundancy. Now, what does redundancy means? An employee is redundant if their dismissal is wholly or mainly attributable to the fact that. So these are the reasons that are valid reasons for redundancies. The first one is the employer has seized or intends to seize the business for the purposes for which the employee has been employed. So let's say you were doing a business in which you had hired different types of employees. Now you are seizing, or you are going to shut down that business. So it means that, if you are shutting down the business, then employee have to leave the business. So they will be treated as redundant. Clear?
Okay.
The employer has seized or intends to seize, carry on the business in a place where employee was employed. You are not shutting down the complete business, but a certain branch you are shutting down in which that employee was hired. This is also redundant. Like, for example, I gave you an example that, let's say you are operating a restaurant and you have branches in different cities. Now, three different cities. Now, if you are shutting down a branch of one city, so it means, the employees of that cities, they have to leave, right? They have to leave. They will be now known as redundant. And the third one is the requirement of that business for employees to carry out work of a particular kind, or for them to carry out the work in place where they were so employed, have ceased or diminished. You hired an employee for a particular kind of work or a particular skill, but now, you don't require that. You are seizing that, so that employee will be treat as redundant. Like, for example, you have a restaurant and you hired a chef who was specialized in, let's say, Italian foods. Now you are going to introduce Chinese foods. Now the chef, who was specialized in Italian food, he's not specialized in Chinese food. So if you will, if you have to, then if the particular kind, that kind of the work is now no longer, this is no longer required, so that employee have to leave the company. So he will be redundant. Okay, he will be treated as redundant. Clear?
Okay.
Complete business is shut, either one branch is shut, or the particular kind of the work, you no longer require that anymore, that is seized or diminished. Then in these three situations, the employee will be treated as redundant. Now, there is a proper process for the redundancy that you have to follow. Redundancy consultation process. You have to consult your employees. Now, how do you do that? Let's see. If you fail to consult employee and their representatives, if applicable, in a redundancy situation, the redundancy dismissal will almost certainly be unfair. If you did not consult the employees or their representatives, like, let's say, trade union representatives, about the redundancy situation, then all of the redundancy dismissals will be considered as unfair dismissals. So it means that you have to consult with employee. Okay. Now, how to do consultation? If you plan to make 20 or more employees redundant in one place of work within 90-day period, this is also known as collective redundancy situation. You must notify for the Department of the Business, Energy, and Industrial Strategy and consult with workplace representatives. These may be either trade unions, or where there is no union, elected employee representative, or if your employees choose not to elect employee representatives, you must give relevant information directly to each individual. So if you are going to make 20 employees or more redundant in upcoming 3 months, then you have to notify the Department for the Business, Energy, and Industrial Strategy, and you have to consult with workplace reps. You have to let the trade union representatives or employee representatives, or if there is no union or there is no elected employee representative, you have to directly communicate that information to every individual who you are going to make redundant. Okay, got the point?
Yeah.
Consultation must start in good time. You have to start the consultation in right time. Now, what is the right time? When redundancy proposals are in their formative stage, and at least 30 days before the first redundancy, where 20 to 99 proposed, where there are 20 to 99 proposed redundancies. If you are going to make redundant 20 to 99 employees, then you have to let those employees know 1 month before. Okay, you have to consult them 1 month before. And if the redundancy is more than 100, then you have to consult them 1.5 months in advance. Okay, now what is the procedure for redundancy? The employee must be continuously employed for 2 years, and the claim for redundancy can be bring forward in the 6 months. Within 6 months of dismissal, employee must prove they were dismissed. Now look, the presumption of an employee is that the presumption is that they were dismissed. Okay, they were dismissed. Employee will have to
Yeah.
prove that they were dismissed, while employer have to prove that I did not dismiss them, but I have to make them redundant. Okay, employee must have to prove that they were dismissed, and employer must prove employee not redundant. Okay, I think there's a mistake here. There's a presumption that they're redundant, so employer have to prove that because of the shutting down of the workplace, they have to make employee redundant. I think it's a mistake here. Okay, if found redundant, pay as per basic award for unfair dismissal. Now the thing is, if let's say employee have proved that they were dismissed. Okay, if employee have proved that they were dismissed, then they can claim an award of unfair dismissal, basic award plus compensatory award and additional award as well, if they prove that that they were unfairly dismissed. But if they were found redundant, they will only get what? They will only get basic award. Okay, so that is why employee try to prove that they were dismissed so they can get more awards, while the employer just have to prove that they were redundant, and so that they are only entitled to the basic award, redundancy award. Okay, the basic award is the same that we just talked about in unfair dismissal. Clear? Now there's a case here. A pastry cook was dismissed because the requirement for his specialty eclairs and meringues had ceased. He was replaced by a new pastry cook whose specialty was a new requirement. It was held that the dismissed pastry cook had been dismissed for redundancy, as the need for the particular work he contracted to do had ceased. He was made redundant, and he was made redundant rightly, right? Because the requirement of that work is no longer, the requirement of the specialty is not needed anymore. Okay, got the case?
Yeah.
Now there's another case. Please read the case.
The current public was modernized by installing a discourse. The 57-year-old barmaid, Miss Wall, was dismissed in order to make way for a younger, more glamorous barmaid.
Yes. Now the thing is, there was a quite public house that was modernized, by installing the new things, and there was a maid. She was 57 years old, whose job is to, serve the employees. Now she was dismissed. Why? Just to bring a younger, more glamorous maid. Now, the thing is whether she was redundant or not. She was not redundant. Why? Because the work that she was doing, that work is not changed, right? The maid
Yeah.
who is 57 years old or who is even 20 years old, they have to serve the employees, right? So the particular kind of the work is same. There is no change in the nature of the work. So she was not made redundant. She was unfairly dismissed. Okay. Redundancy pay. Redundancy pay is calculated in the same way as the basic award for unfair dismissal. We have already talked about that. Now there are some important points. However, an employee is not entitled to redundancy pay if they unreasonably refuse to offer fresh employment made before the old contract expires to start within 4 weeks on same or suitable terms. The employee must be allowed at least 4-week trial period on the new job. The first thing is that if you are made redundant, you will get the basic award. Okay, that we just talked about. The second thing is, if let's say if the employer told you that we are going to shut down the business, and he offered you a fresh employment somewhere else. Okay, he offered you same kind of employment somewhere else, and if you refuse that employment, then you are not entitled to redundancy pay. Got the point?
Yeah.
But the thing is, employee should be given at least 4 week trial period. Employee should be given at least 1 month trial period, in which he or she can decide that whether the kind of the work that we are doing here is the same as compared to the old one, or whether we can do the work or not. So at least 1 month trial period should be given to them. But if they unreasonably refuse the offer, then they are not entitled to redundancy pay. Now the next paragraph, whether the alternative employment offered is suitable or the offer was unreasonably refused are both question of the fact, to be determined by reference to such matters as employee's skill and working condition, the requirement of his or her family, change in earnings, age, health, sex. Any dispute arising in this respect is for the tribunal to determine, and the onus of the proof is on employer. Now the thing is, if you are taking an alternative employment, then the court have to decide whether the alternative employment is suitable or not. The alternative employment can be unsuitable if, let's say, the occupation have changed. You were working in some other post in the previous company. The new employment says you are working in some other post. Okay, it can be due to change in earnings. Like in the previous company, you were getting £10,000 a year. Here you are getting £7,000. It can be because of the change of the place. Like for example, you were working in London, but now you have to move to Manchester. So the alternative employment is, it is not a suitable in this case, right? Because you have to move with the family. So these are the factors that are considered while the you know the tribunal have to decide whether the alternative employment is suitable or not. If it is not, then the employee have option to cancel or reject that alternative employment and claim for redundancy dismissal. Okay.
Okay.
Now please read this case, the last case, and the chapter is done.
T was headmaster of a school. The school was amalgamated with another school and a new head appointed to the combined school. He was offered employment in a pool of teachers standing in for short periods in understaffed schools. He should retain his current salary.
So what do you think? That he was headmaster before. Now the two schools were combined, and now he's a teacher. So is the salary is same? Is the employment suitable?
Sorry?
Is the alternative employment offered to him is suitable? He was headmaster
Yeah,
of the school, and there were two schools. He was headmaster of one school. Now the two schools, they were combined, and when they were combined, now he was appointed as a teacher in the new school. Before he was
yeah,
headmaster, the salary was same. So can he
yeah.
reject the offer or not?
Can reject
Because
because the position.
yes, position is changed. Regardless
Yeah,
of the salary, the position is changed. He was headmaster before, and now he's just teacher. So he is
yeah.
entitled to reject the offer, and he can claim a redundancy payment. Why? Because in regard to the status, the employment is not suitable.